Dr. Gilad Noam is a Deputy Attorney General for International Law. He, along with his team, represented Israel at the International Criminal Court in Hague. He was leading the negotiation on behalf of the State of Israel in many international discussions and agreements. And he is actively working to advance Israel as international hub for arbitration. And one of the main topics he promoted was the International Commercial Arbitration Act, which adopted the UNCITRAL model law. And Gilad, speaking of creating the infrastructure, what this is our panel is about, why is it so important to pass the International Commercial Arbitration Law at the Israeli parliament, and what are the main topics that reflect this idea and enable to facilitate international arbitrations in Israel?
Good morning. Thank you, Menashe, for the kind words. Just maybe a slight amendment. I was not representing Israel before the International Criminal Court, which is the ICC, which is an acronym well known for this forum in another context. We represented Israel in front of the ICJ, the International Court of Justice, but the ICC is also another headache for Israel recently that we are dealing with. But here I am here to talk about some more positive developments. So it's really a pleasure to be here. It is heartwarming to see the gathering of colleagues from Israel and from abroad, despite everything that is happening, and we are still able to hold this event and to work together towards strengthening Israel as an attractive seat of international arbitration proceedings. So I'm really glad to have the opportunity to share briefly some of the insights regarding the new, as you mentioned, the new International Commercial Arbitration Law, which we believe is an excellent news for the State of Israel and Israeli business and legal communities and their international partners. The international business community has long recognized the advantages of resolving commercial disputes through agreed dispute resolution mechanisms, rather than through state courts. I think we all share this idea. These agreed mechanisms allow the parties to define the rules of the game at the beginning of their relationship, providing legal certainty and avoiding the complexity of litigating in foreign courts and enforcing judgments across borders. Today, mediation and arbitration are widely accepted as the two primary methods for resolving international commercial disputes outside of domestic courts. Arbitration, in particular, plays a crucial role in resolving disputes between parties from different countries, facilitating international business and promoting economic growth and prosperity. So, I'm very happy to share what many of you know, that this year Israel adopted the UNCITRAL model law on international commercial arbitration. The model law reflects the most comprehensive and widely accepted international framework for conducting international commercial arbitration proceedings. It is the result of years of work led by my department, particularly Advocate Eyal Weiner and Advocate Itai Apter from my department, supported by our good friends, many of which are here today from the international arbitration community in Israel and abroad. I am proud to note that UNCITRAL Secretariat added Israel to the public list of countries and jurisdictions that have adopted the model law just weeks after the legislation was adopted. So these are great news in 2024. Terrible year for Israel, but at least here a positive perspective. This step clearly demonstrates the degree to which Israel's law aligns with the provisions of the model law and the high standards it sets for conducting international arbitration proceedings. It also strengthens the message that Israel is committed to creating an optimal environment for promoting international trade and investments. I will provide a brief overview of the key features of this law. The model law is both modern and flexible. It enables the parties to choose the rules that best suit their needs, including the ability to rely on the arbitration rules of international arbitral institutions. The law clearly outlines the stages of international arbitration, from the arbitration agreement to the enforcement of the arbitral award. This creates legal certainty and allows the parties to plan the process efficiently. Furthermore, the law provides arbitrators with substantial discretion to manage the proceedings independently and efficiently. It limits courts' intervention in international arbitrations seated in Israel, and under certain circumstances allow arbitrators to issue interim measures with the assistance of the courts. By adopting the model law, Israel has proudly aligned itself with a growing number of countries where arbitration proceedings adhere to internationally global standards. This law enhances Israel's attractiveness as a seat for international arbitration, as it provides a robust and attractive legal infrastructure for conducting international arbitration proceedings. I heard the previous panel. I think this is an important element. Of course, there are many other issues that need to be addressed, but I think it is something that will promote, an important element that will promote Israel as an attractive place for seat for international arbitrations. It allows all parties to benefit from what Israel has to offer, also the issues discussed in the previous panels, including the expertise of its excellent legal industry. I am confident that the model law will be extensively used by the Israel business community to resolve commercial disputes effectively with its foreign counterparts, contributing to the growth of the Israeli economy. I trust that these features of the model law will lead international parties seeking to resolve disputes, whether between themselves or with Israeli parties, to choose Israel as a preferred seat of arbitration. Alongside the new legislation, I am pleased to see that in recent years, Israeli lawyers, many of whom are present here today, have become increasingly specialized in international arbitration. The combination of these factors, as discussed also in the previous panel, could position Israel as a preferred seat for international arbitration in the coming years. The Ministry's of Justice commitment to promoting international arbitration in Israel extends beyond the adoption of the model law. Israel is an active and leading member of UNCITRAL and participates in the shaping of international legal norms designed to facilitate international trade and to efficiently resolve international commercial disputes. Just one example. Just recently, the UNCITRAL plenary adopted recommended model clauses for expedited arbitration known as SPEDR, Specialized Express Dispute Resolution. This initiative was largely led by Israel, aiming to meet the international needs of the high-tech and startup industries, both in Israel and globally. The UN General Assembly is expected to adopt a resolution welcoming the adoption of the SPEDR in its upcoming session. So another good news from the General Assembly, very unlikely for Israel, but again, I'm trying to search for the positive perspective. So I hope we won't need to balance them with any bad news. I thank you all. I look forward to our next meeting where I hope to share new and exciting developments in our continuing journey to position Israel as a leader in promoting international dispute resolution frameworks. Thank you.
Thank you so much, Gilad. Yeah, we look forward to invite you next year and see where we are. Asaf Niemoj is partner in Meitar. He specializes in international arbitration and cross-border dispute resolution. He's highly experienced in representing clients in Swiss chambers and the LCIA. Asaf worked in London for 5 years and is still teaching international commercial arbitration at the University of Bedfordshire. And Asaf is a member of our legislative team. How would you describe the process that we had in drafting the international rules, our main goals, and could you give us some examples, please?
Yeah, so let me start by apologizing on Yuval's behalf. So Yuval was supposed to be here and to talk about the rules. Ironically, he is in court, so he was unable to be here on time. For me personally, it's a very exciting event today because it's a milestone in a very long journey that started actually back in 2019. So when I came back to Israel after a few years abroad, I had two conclusions. One was that, I used to work for a very, very good law firm in London, and it was a very high quality and high level of lawyering. But I kept thinking that, the level of the lawyers in Israel, I'd say, is at least as good. And the second thing that I kept thinking is, I think it was Daniel who spoke about community, that there was no community of international arbitration lawyers in Israel. So I picked up the phone and called Nuna of Gornitsky, whom I know from London, and then I think I emailed Tzvika, and he introduced me to Maya, and we formed a group of arbitration nerds. The purpose was to create a community, and we started, meeting once a month as part of what we call the Israeli Forum for International Arbitration. And the purpose was to promote arbitration in Israel, and we have identified two major issues. One was, of course, that we don't have a proper arbitration law, and that was dealt with by the guys from the Ministry of Justice. They did a great job, and they were very cooperative, so it was a pleasure to work with them, and we do have a unilateral model law now. And the second was that there was no real alternative to all the major big institutions that we know from the ICC, the AAA, the ICDR, etc. And then we said, okay, what can we do about it? Let's meet Menashe. And that's how the process started. And I think there were three main things that we wanted to achieve. The first, we were given the opportunity to create the international arbitration rules of our dream. So we had a lot of freedom and, working together with you and the institution team, we could take all the good things that we saw in all other jurisdiction and get rid of all the things that we felt are, not as good. The second thing was, of course, to make sure that we still, the rules correspond to what the trends are in the other major jurisdictions, and we made sure that all the things that are common in international arbitration are incorporated into those rules. And the third thing was to make sure that we knew that there is a new arbitration law coming up very soon, so we wanted to make sure that everything that is incorporated into the new rules would also correspond to the new law. Hopefully we did a good job. I think the next step would be to hopefully see how users react to those rules and maybe get some feedback. And time to time there is a new version of the rules. We see that almost everywhere. So hopefully it's a good rules, and let's see what future brings up.
Thank you, Asaf. And by the way, you can judge by yourself. You have the international arbitration rules on your table, and you can take it and look at it. Thank you, Asaf, and thank you for your excellent team for doing a great job. And we talked about, thank you.
By the way, it's also important to say it was a teamwork. Together with me was Maya Nussbaum, as you said, and Gidi, and all other, Yuval, of course, who's not here, but also the other members of the Israeli Forum of International Arbitration who saw the rules and gave her their comments. So thank you, everyone, for the work on the rules.
That's a great teamwork. So we talked about the model law, about the rules. Let's talk about the court. And we have Dr. Daphna Avnieli, the former Tel Aviv District Court judge, and Daphna is the head of the Institute of Legal Arts at the Faculty of Law at the Tel Aviv University, and a valued arbitrator at the IICA. And Daphna, as a former judge, having the model law, having this infrastructure here in Israel, what do you think should be the court approach to arbitration proceedings and awards following the adoption of the UNCITRAL model law?
First of all, good morning, everyone. It's really nice to see a full room of participants here who have come and shown an interest in the conference and the inauguration of the new center. So thank you, everyone, and thank you, Menashe, especially because I've been working with the Commercial Arbitration Center for 7 years now already, and I've been a judge for 25 years, so I think I have a good perspective of comparing the judgeship or my role as a judge for so many years before, for 25 years, and my role as an arbitrator now for the past 7 years. I think it's a great opportunity now to introduce to the legal community, international legal community, and the community in Israel, the IICA as a commercial center for international arbitrations because, first of all, of the human resource that the IICA has now. It has a magnificent roster of arbitrators who are well acquainted with local arbitration and international arbitration. Some of them I can see here today, many of them still are not here, but the IICA has such a knowledge and intimate relationship with so many arbitrators that it can also recommend arbitrators for international arbitration proceedings. And it is very important, once you choose the place of arbitration or the seat of arbitration, you have to choose the arbitrator himself or herself. And I think the parties who are foreign parties come from other countries and are not very familiar with the roster of arbitrators here in Israel should rely and must rely and are recommended to rely on the expertise and knowledge of the IICA, intimate knowledge and acquaintance with arbitrators, because we have former judges. I say we because I'm part of this institute, but I'm not working in the institute. But they have, really, I should say, they have a magnificent number of former judges, including some of my colleagues who are seated here today as part of the participants, lawyers who are well acquainted with local arbitration proceedings and international proceedings. So this is a very first benefit that I should name. The second thing is the established expertise and arbitration of the IICA, which has been, as Mr. Lin has mentioned in his speech before, a long experience and a long history of commercial arbitrations. Because it is really concerned and situated in Tel Aviv, in the center of Tel Aviv, and really promotes commercial arbitrations, which are the main topics that international arbitrations are interested in. The other thing is that was mentioned in the other panel is the very good relationship with the court system. Now, the court in Israel is so heavily loaded with cases. I should mention to you that we have about more than 70,000 lawyers in Israel, but only about 660 judges in the judicial system altogether. So the workload is really terrible. I should tell you this from my own experience. A judge has to deal with so many cases, and he has a backlog of so many cases that he has to write decisions on. And this is one of the reasons why the courts enforce and appreciate arbitration contracts where where the parties decide or are really encouraged to go to arbitration proceedings. The relationship between the arbitral proceedings and the court is very, very good, so that you can get much assistance from the court. The Israeli court is very friendly and acquainted with arbitral proceedings, both local and international. So this is a good point that was made before, and I think you should endorse this point, because in other countries, maybe it's the accessibility to the court system may be more difficult than in Israel. The other thing that I should mention is the capacity to promote arbitration proceedings, which the IICA has very much experience in. And we are now in the process of educating lawyers and introducing them to the choice of arbitration proceedings and mediation proceedings. It starts in the law faculties. Nowadays, students are well acquainted with these proceedings. also in my institute that you mentioned, we have courses in arbitration, in a local and international arbitration. Some of the present colleagues here are lecturers in my institute. And the aim of this institute, my aim really as head of this institute, is to introduce arbitral proceedings, both local and international, to new-coming lawyers and to old-fashioned lawyers. I myself, when I was a student, a law student, I knew nothing about arbitration or mediation, which was not even a topic or a name in Israel. You had to introduce this name in Israel, arbitration and mediation, for people to get acquainted with. The strategic position also of Israel, situated in the Middle East, can be a very good reason why to choose Israel as a strategic position for both Mediterranean, European, and beyond proceedings for people. It's easy accessibility to Israel, so I think it's another point that should be mentioned. All in all, I think and I hope that we shall promote this center from now on. And I anticipate it will be not very easy in the beginning, as was mentioned before. It takes time to introduce a new institute. But we are all committed to this procedure, and we all think that it's a very good idea to introduce it now.
Thank you so much, Daphna. So we have the model law, we have rules of arbitration, we have an institution, and we hope that the court will follow as expected and respect arbitral awards and arbitral proceedings that are is here in Israel. And Eyal, I would like to talk about you. Eyal is one of Israel's leading and most respected litigators. He was a candidate for the Supreme Court, and he is the author of the book Secrets of Litigation, which is one of the first books in Israel dedicated to litigation. And Eyal, as being as an international arbitrator, both in Israel and ICC and other international institutions, let's talk about the human factor here in Israel.
בוקר טוב. לפני שנתחיל, משפט אחד בעברית. אני חושב שחשוב שהוא יאמר בכל אירוע שבו נפגשים אנשים היום בישראל. אנחנו צריכים לקוות במהרה שהמלחמה הזאת תיגמר ושהחטופים יוחזרו לביתם. מי ייתן כמה שיותר מהר, כמה שיותר חטופים חיים. Some personal notes. The world of arbitration allows a lawyer like me occasionally to the transition from being a litigator representing a party to the position of an arbitrator whose role was to decide in a dispute. More than once during my career I have been appointed as an arbitrator. Then sitting as an arbitrator I realized how difficult the work of a judge is. Because as a lawyer, as a litigator, you know, you just have to raise a valid argument and the judge will decide. You don't have to be responsible for the correctness of the argument. You are raising it and then you leave it for the judge to decide. And when you are appointed as an arbitrator and then you have to decide what is right and what is wrong, it is very, very difficult, and you realize how difficult the task of being a judge is. In international arbitration, the challenge is even greater. There is differences in the mentality. When an arbitrator is an Israeli, like myself, and the representative of the parties, or one party is not Israelis, we need to adapt to each other. Let me give you an example. A few years ago, I was one of 3 arbitrators in an international arbitration with Daniel Schimmel and Zvika Bar Natan, who are both here. That took place in Israel. One of the parties in this arbitration was represented by English barristers. During the evidentiary hearing, I allowed myself, as I always do, to ask the witness questions and even to cross-examine them when needed. The English lawyers were quite surprised and even upset by the activism that I displayed towards the witnesses. They were crazy. However, when later they saw that I and the other arbitrators as well acted in the same manner with the witnesses of the other party, they calmed down. By the way, in this arbitration, I gave the minority opinion, which of course was the right one. Alas, the judgment was the majority's decision of my friend. Personally, I'm not very optimistic about succeeding here in Israel to create a center for international arbitration. Of course, it will only work when one of the parties will be Israeli or when the conflict will have a very tight connection to Israel. Here there is, but we will not be a place for an arbitration for a Norwegian company suing a Dutch company regarding business in Cyprus.
Let's start with something.
Yeah.
Thank you so much, Eyal. And last but not least, David Zaslovsky from Baker McKenzie, which specializes in resolution of complex international commercial disputes, particularly in the fields of technology, energy, and infrastructure. He was recognized in the Chamber of USA Guide and the Chamber Global Guide for his expertise in international arbitration. And David, actually we can summarize the whole panel here and the whole event here, but we have a really high level of arbitrator lists from worldwide, and so many, as Shai said, so many countries, so many top leading international arbitrators, and perhaps with all the talking about infrastructure, model law, rules, human effector, and the institution leading this Israeli center, how would you summarize the prospects of having this?
Right, so let me, first of all, I am thrilled to be here. I really am. And yeah, let me do that, right? I'm a litigation lawyer, I'm an arbitration lawyer, so let me make the closing argument, and I'll touch on things that everyone has said. And do it sort of in the context of what Sarah was talking about. If you're having a conversation with an in-house lawyer and you're talking about the place of arbitration and how are you going to have that conversation without in-house counsel and have them choose this new center. And I'll touch on experience that I've had or I know of others. And so you have a checklist of items that you're going to talk about. So we've talked about the soft law items, right? So the adoption of the inter-trial model rule is certainly going to help in that regard. You need to look at the rules of the institution, and as we heard, there's a set of new rules that pick the good parts of various arbitration rules that already exist, and so the rules is something that is favorable. We've all, when we've talked to our clients, said the most important thing you have to do in arbitration is choose the arbitrator. And so you look at the list of arbitrators, and Shai spoke about that before. And statistically, in international transactions, English law, choice of English law is number one, choice of New York law is number two. And so that list has English lawyers, and it has U.S. lawyers, and as Shai said, right now at least lawyers from 15 different countries. So that is an important issue. You also have real infrastructure issues, and this is something that I saw in a case that I worked on. Putting aside the situation right now, you need an airport that's a easy place to reach. Ben Gurion, again, putting aside the current situation, is that is a real infrastructure issue. What used to be an infrastructure issue, court reporters, right? Some of us just see it on television, right? But real-time court reporting, that is less of an issue now because ever since COVID, that is done remotely. So that is not going to be a problem. Technology is an issue, and of course, state-of-the-art technology in this case. Having a center, a physical center that could have hearings, and you and I discussed that. So you're not building here on an empty plot. You have the existing center. Someone said before, a hearing room with 3 hearing rooms with 120 people. very few places could have that anyhow. So that's not real. The question is, do you have a hearing center where you could have a normal size hearing or even a large size hearing? You said you could have 40 or 50 people, breakout rooms. So you have that as well. As Sarah said, it's going to grow, right? At the beginning, it's not going to be easy. How will it start? It will probably start with Israeli companies negotiating with non-Israeli companies, and the Israeli company has the leverage, and they will be able to say, I want arbitration in Israel, which for the foreign party is going to be preferable than the courts in Israel, because nobody wants to be in the courts of the other side. So that's how it will start. And then it will grow. There's a saying in English, I don't know if there's anything equivalent in Hebrew, but the best time to start a new task is yesterday, and the second best time is today. And so here today on the launch of this new center, and let's go.
Thank you, David. So we're starting today, and with your help, we can make it happen. So thank you so much for coming today. Thank you for the speakers. Thank you to everybody. And יום טוב לכולם. תודה רבה.